India is creating fast-track courts for question paper leak cases. The Prime Minister recently announced the decision promising swift trials and stringent punishment. And within hours, the Delhi High Court designated a special court to exclusively handle paper leaks and other unfair practices in public examinations. But here is the real question. Can calling a court fast track actually make justice faster? Or will the same delays simply enter a courtroom with a new name? In this video, we will break down what these courts actually are, how they work, what the constitution says, and why faster hearings may still fail without deeper judicial reform. First, a fast track court is not a court that skips legal procedure. Think of it like an express lane at a supermarket. The rules for payment remains the same, but fewer customers are placed in that lane and the line is supposed to move more frequently. Similarly, a fast track court receives a selected category of cases and gives those cases priority. It may conduct frequent or day-to-day hearings. It may impose tighter controls on adjournments. It may fix schedules for witnesses and closely monitor delays. But the accused still has the right to a lawyer, access to prosecution material, cross-examination of witnesses, defense evidence, a reasoned judgment, and an appeal. Speed cannot replace a fair trial, and a fast-track court is not always a newly constructed court. An existing sessions court or another competent trial court may simply be designated to hear one category of cases on priority. The government and the judiciary have different roles. The government may identify the need for specialized courts. It may provide money, buildings, judicial posts, prosecutors, and support staff. But the relevant High Court controls the subordinate judiciary. The High Court normally decides which judge will preside, which cases will be transferred, and how the court's roster will operate. That separation matters. The executive may propose and fund a specialized court. It cannot tell the judge how to decide an individual case. India does not have one central law establishing and regulating every fast track court in the country. Different courts have been created through Finance Commission recommendations, government schemes, state decisions, High Court notifications, and directions from constitutional courts. That means their jurisdiction, funding, and administrative structure can vary, but they do not normally apply a completely different standard of justice, unless Parliament or a state legislature expressly provide otherwise. A fast-track court follows the same criminal law, procedural safeguards, and rules of evidence as an ordinary court of equivalent jurisdiction. The main difference is priority and case management, not a lower burden of proof, not automatic conviction, and certainly not punishment before guilt has been established. The constitutional foundation comes mainly from Article 21 and 14. Article 21 protects life and personal liberty. In the landmark Hossain Ara Khatun case, the Supreme Court declared that the right to a speedy trial is part of the fair, just, and reasonable procedure guaranteed by Article 21. The case involved under trial prisoners who had remained in jail for extremely long periods, sometimes longer than the maximum sentence they could have received. But speed has a second constitutional limit. Article 14 requires equality before the law. In Anwar Ali Sarkar, the Supreme Court warned that the desire for speed cannot give the government unrestricted power to pick individual cases for a special procedure. The category must be rational. For example, all paper leak offences under a defined law can be prioritized. Selecting one politically sensitive accused person for exceptional treatment would be far more constitutionally problematic. And in P. Ramachandra Rao, the Supreme Court rejected the idea of one rigid deadline for every criminal case. A simple case with two witnesses cannot be treated like a conspiracy involving dozens of accused persons, digital records, and forensic evidence. The constitutional requirement is reasonable speed, not a mechanical stopwatch. Fast track courts are not a new experiment. The modern program began after the 11th Finance Commission recommended 10734 fast track courts for the period between 2000 and 2005. Around rupees 500 crore was sanctioned. These courts focus heavily on long pending session cases and cases involving under trial prisoners. The scheme was extended, but central financial assistance ended in March 2011. States were then free to continue the courts using their own resources. The Supreme Court later made an important point in the Brij Mohan Lal case 2002. Temporary judges and short-term schemes cannot become a permanent substitute for a properly staffed judiciary. Fast-track courts may relieve pressure, but lasting reforms require regular judicial appointments, permanent infrastructure, and stable funding. There is evidence that specialized courts can dispose of cases more quickly. Fast track special courts dealing with rape and POSCO cases have averaged approximately 9.51 disposals per court per month. Comparable regular courts average around 3.26. That is almost 3 times the monthly disposal rate. The Department of Justice dashboard currently lists 775 functioning fast-track special courts, including 398 exclusive POSCO courts. Together, they have recorded more than 3,87,000 cumulative disposals. But more than 2,49,000 cases are still pending, and disposable does not automatically mean conviction. A case may end through conviction, acquittal, discharge, withdrawal, or transfer. Fast disposal tells us how quickly files are leaving the court. It does not by itself tell us whether the investigation was wrong or the final outcome was correct. The biggest problem is that a criminal case is not processed by the judge alone. Imagine a factory production line. Even when the final assembly station is fast, the product cannot be completed when the earlier stations stop working. A trial depends on police investigations, it depends on forensic laboratories, it depends on prosecutors, prison authorities, process servers, and witnesses. If a forensic report arrives 6 months late, the judge cannot manufacture it. If witnesses repeatedly fail to appear, a special courtroom cannot magically produce them. If the accused is not brought from prison on time, the hearing may still be adjourned. There is also the question of additional capacity. Suppose a judge is transferred from an ordinary court to a fast track court, but nobody replaces that judge. The specialized court becomes faster, the ordinary court becomes slower. The backlog has not disappeared, it has simply moved. Numerical disposal targets create another risk. Targets can discourage unnecessary adjournments, but extreme pressure can also reduce preparation time, limit meaningful cross-examination, or produce poorly reasoned judgments. A fast but unreliable trial is not justice. Fast track courts can deliver faster justice. India's experience shows that a specialized court can dispose of more cases when they receive focused judges, staff, and resources. But a new label on a courtroom is not judicial reform. The real test is whether these courts receive additional capacity and whether speed is achieved without sacrificing fairness. So what do you think? Will fast track courts deter paper leaks, or will they simply move the same backlog into a different courtroom? Share your views in the comments. Now let us revise what we have learned through a MCQ. With reference to fast track courts in India, consider the following statements. Statement 1. All fast track courts are established under a single central legislation. Statement 2. High courts generally exercise administrative control over the designation of judges, allocation of cases, and preparation of court rosters. Statement 3. The Supreme Court has recognized the right to a speedy trial as part of Article 21 of the Constitution. Which of the statements given above are correct? Option A, 1 only. Option B, 2 and 3 only. Option C, 1 and 3 only. Option D, 1, 2 and 3. The correct answer is B, 2 and 3 only. Now let us come to explanation. India does not have one central law that uniformly establishes and regulates all fast-track court. Hence, statement 1 is incorrect. Under the constitutional framework, the concerned High Court supervises subordinate courts. It generally designates the judicial officer, transfer or allocates cases, prepares the roster, and monitors the functioning of the fast-track court. Hence, statement 2 is correct. In Husainara Khatun versus State of Bihar, the Supreme Court held that the right to a speedy trial is part of the fair, just, and reasonable procedure guaranteed under Article 21. However, speedy trial does not mean that fair trial safeguards can be ignored. Hence, statement 3 is correct.